So, good morning, everybody. Welcome to the first European edition of our Digital Transformation Academy webinar series. Today, we'll delve into one of the hottest topics currently being discussed at European level, which is the proposed Digital Omnibus, a set of rules published in November last year by the European Commission with the aim of streamlining and simplifying the current European Union legal framework on digital regulation. Over today's session, we'll try to unpack for you the most relevant provisions of this proposed regulation, addressing the rationale behind the digital omnibus, telling you where we are with the legislative process, and then focusing on the key proposed modifications to certain legal acts of the European Union, specifically the AI Act, the Data Act, the GDPR, and e-privacy legislation, as well as other relevant provisions set forth by these draft regulations. And prior to kick off, let me introduce you our panelists today. So alongside me, there's Jasper Siems, who is a senior associate in our Hamburg office and who had the idea of organizing this webinar. So we have to thank him for this, as well as Friederike Kurzer, associate in the same office. Both of them belong to the IP and digital regulation departments. Whereas my name is Giulia Mariuz, and I am a partner in our Milan office, where I've been dealing with all things tech law since 13 years. So we will try to make the digital omnibus nice and easy for you. Please feel free to drop any question you may have by using the question and answer button. We will make sure to address your question at the end of this webinar. We scheduled some dedicated time for this, as we guess there's going to be a lot of questions. So before leaving the floor to Frida for a deep dive on the proposed modifications to the AI Act, I'm going to provide you with some background on what the Digital Omnibus is and what it tries to address. So we can move to the next slide. Thank Jasper. First of all, we do say Digital Omnibus, but in reality, we are referring to two separate draft regulations which include proposed modifications to the current European Union digital regulation legal framework. One of these addresses the existing legislation on data, so not only the GDPR and e-privacy legislation rules, but also the legislative acts that have been adopted in the latest years in the context of the European Strategy on Data, such as the Data Act, the P2B regulation, and cybersecurity legislation, while the other regulation is specific to the AI Act. So we're going to refer to these to Digital Omnibus on AI. And both draft regulations are the result of a deep reflection on the status of digital regulation in Europe and to whether the conflated legal production of the last years is somehow hindering Europe's competitiveness. So nowadays, I'm sure all of you are facing challenges because operations operating in the European Union must satisfy multiple overlapping legal regimes across different domains. So we're not only talking about data protection and cybersecurity, but there's also artificial intelligence and then data legislation more in general. To give you an idea, the European Union Digital Regulatory Stack comprises at least 7 distinct instruments, each providing for its own scope, obligations, supervisory authorities, and sanctions. So the challenge here is no longer understanding each instrument in isolation, but also trying to understand how all of these instruments interplay in between them and have somehow come up with a sensible and secure compliance framework. And the risk here, it has been highlighted by the Draghi and Letta's reports over the last years, is that of over-regulation. So in this context, the Brussels effect, as it is known, risks turning from a golden standard from the protection of fundamental rights to a burden that ends up undermining the competitiveness of European businesses compared to those operating in other jurisdictions, such as the United States, China, or India. And moving from such concerns, the European Commission held a series of consultations, including in-depth assessments as to potential challenges in the implementation of the AI Act, which reveal, on the one hand, the need to simplify and streamline the current setup, and on the other hand, specific implementation challenges that could jeopardize the effective application of the key provisions of the AI Act. And as a result, the European Commission issued the Digital Omnibus proposal back in November last year. So, as anticipated, the two draft regulations pursue similar objectives, although they move from slightly different places. Because for the Digital Omnibus on data, the starting point is the lesson learned from almost 10 years of GDPR, as well as the overproduction of legal acts in the realm of data that took place in the last 5 years. Many pieces of such legislation, such as the Data Governance Act, haven't played out as expected, with the result that they remain basically unapplied. So there was really the need of streamlining and simplifying the legal framework to ease the compliance burden on businesses. And we're going to see the proposed modifications really go in this direction. In turn, the Digital Omnibus on AI aims at addressing the implementation challenges that have been perceived regarding the AI Act, which I'm sure some of you know came into force in August 2024, but is subject to a phased implementation. So the idea is a legal act that is not entirely enforceable and entirely applicable yet is already presenting implementation challenges. So among others, based on the assessment carried out by the European Commission, it resulted that the lack of harmonized standards for high-risk AI systems, as well as the delay in establishment of governance, conformity assessment, and appointment of national competent authorities, borne the risks of increasing compliance costs and burden for businesses, ultimately slowing down innovation. So really going against the aim based on which the AI Act had been originally conceived. So the Digital Omnibus package is still a work in progress, meaning that we're still talking about draft legislation that will become final and enforceable only at the end of the legislative process. And in this regard, it's important to highlight that the Digital Omnibus on AI is slightly more advanced than the Digital Omnibus on data, as it already underwent a read by the Council and the Parliament, while the Digital Omnibus is still at the Commission's proposal, although in the meantime, its provisions have been commented by member states such as France and Italy, and also by other institutions. So, for instance, the European Data Protection Supervisor and the European Data Protection Boards issued opinion on both legal instruments, taking position on some of the proposed modifications. And we'll move now to the real meat of this webinar, and I'll leave the floor to Frida, who is going to guide you through an analysis of the key proposed modifications to the AI Act.
Thank you very much, Giulia, and good morning, everybody. As already mentioned, the Omnibus package also includes changes to the AI Act, which we will take a closer look at now. I am sure that most of you will already be quite familiar with the AI Act, but I would nonetheless like to give you a very brief recap on this important piece of legislation. The EU Artificial Intelligence Act, often just called the AI Act, regulates the use of artificial intelligence to ensure that it is trustworthy and safe. To achieve this goal, the AI Act uses a so-called risk-based approach, which means that the requirements get stricter as the perceived risk of the AI application increases. In terms of its addressees, the Act is a broad and cross-sector law that applies not only to tech companies, but to public and private actors with EU exposure. The Act entered into force on the 1st of August 2024, but, and as Giulia already mentioned, its rules don't kick in all at once. They are in fact being phased in over a period of several years, as you can see from this timeline on the slide. An important date to note here is the 2nd of August 2026, which is of course only a few months away. This is when the main provisions of the AI Act become applicable, including obligations for so-called high-risk AI systems. This includes systems in sensitive areas such as recruiting, credit scoring, medical devices, and so on. This date, so the 2nd of August 2026, is also when the watermark requirements for generative AI systems become applicable. This means that any outputs that stem from such AI systems must be marked in a machine-readable format and also be detectable as AI generated or AI manipulated. The Act also includes an extra transition period for certain high-risk AI that is built into other regulated products. This concerns, for example, AI in medical devices, which already have their own product safety laws in place. For those specific cases, as you can see on the very right box of the slide, companies get an additional year, so that means up to August 2027, to comply with the AI Act requirements. Next slide, please. Thank you very much. On the 19th of November 2025, the European Commission published its Omnibus proposal for the AI Act. Since then, Council and Parliament have debated the proposal and they have added their own changes and amendments to it. We will delve into more detail in a moment, but if we just first take a step back, we can see from the slide that the Omnibus covers a very wide range of rules, from delaying high-risk AI obligations to much more minor fixes like clarifications. The main changes that we would like to focus on today are outlined in dark blue. In the following, we have grouped them together as material changes on the one hand and stopping the clock changes on the other hand. Next slide, please. Generally speaking, all stakeholders, and that means the Commission, Council, and Parliament, have agreed to keep the AI Act structure intact, with only a few notable material modifications. The first one is the ban on so-called nudifier AI systems. These are AI tools that can take a fully clothed photo of a person and alter it to produce a nude or sexually explicit image of that person without their consent. Essentially, this is a form of AI-generated deepfake pornography. This kind of misuse is currently a growing concern. And whilst the original Commission's proposal did not yet include any rules on this changed when the Council came in, because the Council has now added a brand new ban on AI that generates such non-consensual imagery, which includes deepfake nudes and also any AI-generated child sexual abuse material. The plan is to add such nudifier systems to the list of prohibited practices of Article 5 of the AI Act. This would then in turn allow very high penalties to be imposed in case of a breach. The Omnibus further suggests a nuanced change when it comes to mitigating AI bias. As you may be aware, the original AI Act already implied that providers should address biases. However, the new amendment explicitly permits AI developers and users to process special categories of personal data strictly for the purpose of bias detection and correction. Both Council and Parliament have insisted, though, that there would be a very high bar for this. Such processing must be strictly necessary for the bias correction aim. So this means that the change is very far from a blanket allowance. It is much rather a targeted carve-out so that any teams that are auditing an AI's fairness can work with real-world data to ensure that AI outputs are as unbiased as they can possibly be. The third change that we would like to flag is the reduced registration of non-high-risk AI systems. So under the current AI Act, providers who invoke that their system might fall in a high-risk category but is actually low risk due to its limited purpose have to register that system. The Commission felt that this was quite an unnecessary burden and they've actually proposed scrapping it altogether. However, the Council has now reintroduced a form of the registration which Parliament largely agreed with. It is thus likely that this requirement will still exist, but possibly as a toned-down registration duty. Another material change for businesses is the inclusion of SMC-friendly provisions. So to make the AI Act more proportionate also for mid-level companies, the Commission suggested to extend certain exemptions that currently apply to small and medium-sized enterprises also to larger ones, the so-called small mid-cap enterprises or SMCs. Those are typically defined as companies with up to 750 employees and under 150 million euro turnover. Following this change, SMCs would get very similar regulatory relief as the smaller SMEs do at the moment. For example, they would have more flexibility in meeting documentation requirements and consideration of their size when authorities set penalties. Next slide, please. Now moving to one of the most significant changes, at least in practice, which is not actually a material one, but of a procedural nature. As already mentioned, the obligations of the AI Act are not all in full effect yet. Under the current Act, most high-risk AI obligations will start by August 26, with some specific cases extending to August 27. These dates are highlighted in blue on the slide. The Commission was concerned that many of the practical tools that are actually needed for compliance, like harmonized technical standards and also guidance, would not be ready in time for these dates. And this is why in the Omnibus proposal, the Commission suggested to link the start of the high-risk AI rules to the availability of the standards and guidance. This link is symbolized by the green illustration at the top of the slide. The idea behind this is actually a very common sense and practical one. High-risk requirements should not kick in until the necessary standards are available so that companies can actually comply. At the same time, the Commission suggests that there should be latest application dates of December 2027 and August 2028. In practice, this means that if the standards turn out to be even more delayed than currently anticipated, there would still be a date for companies to comply. However, this would be an equally delayed date, which then gives companies more time than they currently have. These latest application dates are shown in green on the right side of the slide. We have put the word latest in brackets here because Council and Parliament have so far scrapped the idea of application dates that are linked with guidance or standards. They much prefer those dates to be fixed. Which view will persevere remains to be seen. Another manifestation of the stopping the clock mechanism concerns the watermarking obligation for generative AI systems. As you can see on the slide in turquoise, this obligation will similarly apply from August 2026 under the current AI Act. But once again, the Commission worried that some providers would need more time because they would need to retrofit existing Gen AI systems with technical solutions that would then allow for the watermarking. And this is why the Commission proposed a grace period until February 2027. However, this might still be shortened to November 26, in line with most recent discussions in Parliament. And with this, I now hand over to Jasper, who will talk you through the Omnibus package on the Data Act.
Thank you, Friederike. Yeah, so coming to the next, so second pillar of the proposed reforms, the Data Act. And as you can see here, the Commission is speaking of a Data Act 2.0. So the Commission sees really big reforms coming to the Data Act. But as Friederike did with the AI Act, maybe first to be all on the same page, let's have an overview about the Data Act. What is the Data Act about? The Data Act is about facilitating of data sharing, data of generated by the use of so-called connected products. So we are talking about smart products, smart cars, smart fridges. Nearly every product now of the physical world is connected to the Internet of Things, and by that generating machine data. And the Data Act will try to facilitate for users of these smart products, so the owner, for example, of a smart car, to access these rights. And by that, the Data Act addresses basically the manufacturers or other providers of these smart products. So in the old world, the manufacturers kind of controlled the data, and by that were able to use the machine data or not. And in the, at least ideal world of the Data Act nowadays, users should get access to data and maybe make additional use of that to facilitate in data economy. And what is important, and you can see on the timeline here in the upper side of the slide, is that the Data Act, or the most provision of the Data Act, are already in application. So the Data Act actually applies for nearly or even more than half a year now, since September 2025. And the approach of these data access rights and the Data Act in general is horizontal. So it provides data access cross-sector for every sector. It doesn't matter if it's the medical healthcare sector, automotive, and so on. And it is enforced basically by penalties, so by public enforcement through member state authorities, but there's also the possibility, obviously, of private enforcement to civil litigation or even consumer associations. And because it is quite new and maybe a bit complicated, and still our impression is that the Data Act is not so well known, especially these data access rights are not so well known. Let's look at them in a more deeper sense. So here is the user in these light brown, and the user uses all these different smart products, for example, a smart washing machine, smart car, smart medical device, whatsoever. And these machines, these products generate a lot of data, and these data are still controlled by the data holder, so the manufacturer of the smart car, for example, but no, they are attributed to the user. And actually the data holder, for example, the manufacturer of a smart car, needs a so-called data license, so a contract, or at least provision in its general terms, with the user that the data holder, the manufacturer, for example, of the smart car, is allowed to use these machine-generated data. The manufacturer isn't able to use this data just anymore without these contractual base, and the user needs to get access to the data generated by his or her smart product. And what is also possible, and that is interesting, the user can facilitate data access to user-generated data to third parties, so-called data recipients in light green here on the right-hand side of the slide. And for example, I'm owning a smart car. The smart car is producing a lot of data, and then I can go to the manufacturer of my smart car and say, please allow a third party, for example, a fancy startup developing, I don't know, some enhancement technology, for example, to optimize, I don't know, my tire pressure whatsoever, and please give this startup access to the data generated by my car, so startup can kind of optimize its product on my specific car. So that is really new world in application for half a year now. And maybe because it's interesting to see that the Commission is considering changes to a law which is quite young, actually, just half a year in application. And that is maybe what we see in practice so far could be a reason for that. Because what we do see is when it comes to the mandatory transparency information, so manufacturers informing users about which kind of data generated by these smart products, we see quite good compliance. So many companies are complying with these transparency information in their, I don't know, general terms and conditions, or on their websites, basically, or in their product descriptions. What we don't see are many data licenses. So there's still, in many cases, a compliance gap, at least informed by our latest our latest benchmarking for data compliance. So manufacturers are not all right now in the position to actually use this data based on the Data Act anymore, because many don't have updated their contracts, their terms and conditions with data licenses. What about actually granting data access? So how do companies do that according to our experiences so far? Some use online portals, especially automotive companies and apps. So you maybe didn't even notice, but you could actually access the data of your smart car now, mainly to online portals by your car manufacturer. Some rely on individual requests per email. I think that is kind of inspired by the data protection access approach, but yeah, we aren't sure if this is really compliant and this is what really the Commissioner has in mind. What we don't see much, and we supported some companies or many companies with their initial data compliance, we don't see any, at least no huge number of data access rights. So users right now it doesn't matter if business users or consumer users are quite reluctant to access their data rights, and that might be just because simply they don't know they have these rights now. And that is maybe also why the Commission is pushing for reform of the Data Act, or at least giving the Data Act more highlights. So what we do see on the enforcement side, on the other part of the slide, the Commission published a lot of guidance, FAQs and guidance on vehicle data. Both are quite useful actually to get a better understanding which kind of data are in the scope of the Data Act and model contract terms. But the enforcement of the Data Act lies with the member states, and many member states are just in the early steps actually of establishing the necessary authority. So there's still not much, at least to our knowledge, not much enforcement happening, and we don't have any, court rulings or anything so far. But then again, it's just half a year of applications, so that is quite normal and expectable. So what does the Omnibus now propose? First, the Omnibus proposes to integrate the Data Governance Act, the Free Flow of Non-Personal Data Regulation, and the Open Data Directive. So 3 rather not really well-known data law-related acts into the Data Act. So that is why we speak of the Data Act 2.0. And the idea is to have one rule book for all data laws, except obviously the GDPR. What is the idea behind? So the Commission is hoping by doing this integration to eliminate overlapping rules and reduce fragmentation for companies, and by that cut compliance costs. What we do, what we do see as a caveat to be careful about is that this integration is largely structural, meaning side by side. They just put one act behind the other in the Data Act, and we don't see a real, substantive reform. So how these laws actually interplay with each other, especially also with the GDPR. So that is more a structural than a substantive reform so far, at least what is proposed. That might be, as Giulia described, subject to change in the legislative process still. What are specific amendments to the Data Act? Actually, general observation, not that many, just cautious fixes, no bold reforms so far. We do see a new option for the so-called trade secret handbrake. That means if I don't want to give access to specific categories of data, I do have some defenses under the Data Act. And one of them is to say, actually, these are really important trade secrets for me, and if I share these data with third parties, I as a company may suffer huge economic loss. And the Commission, based on proposal from the industry, is considering or is supposing a new trade secret handbrake, basically relying that these disclosure of this kind of data would result in weaker trade secret protection, because I would disclose these data to third country entities with, for example, from in jurisdiction with weaker trade secret protection. So the idea is there could be companies from non-EU countries who abuse the data access to get competitive advantages to gain information, and that should be at least reduced. Then business to government data sharing is narrowed in scope. On the old approach, it was necessary to share data with governments in exceptional needs, and now it is narrowed in scope to public emergency. And then we do, as Friederike described for the AI, we do also see some changes for small and medium companies to the cloud switching rules. The cloud switching rules are a different pillar of the Data Act aside from data access rights. And basically, just for you as a takeaway, for small and medium entities, it is easier, and there's more grandfathering rules, so they don't need to be compliant right now. There's more time basically to make the transition to the new cloud switching rules. So easier for them. And with that, over to you, Giulia, and the proposed changes to the GDPR.
Thank you, Jasper. So moving on to the next slides. I'm not going to guide you through the GDPR and the e-privacy directive, because by now these are two established pieces of legislation. As you know, there's been in the latest in the years in which the GDPR was into force, so the last 8 years, there's been a close scrutiny of how it played out. And as I said at the beginning, the Digital Omnibus, specifically with regard to the GDPR provisions, really tries to move from the lesson learned with the idea of ease the burden compliance on businesses. On the e-privacy, you may know that there was the project of having an e-privacy regulation to come into force in parallel with the GDPR that was not successful because of resistance in different legislative views across member states. So, starting from the basics, one of the most relevant changes proposed by the Digital Omnibus is about the definition of personal data. And this is just the ending point of a long reflection that span over the last few years. The Commission's proposal amends Article 4 GDPR to codify the most recent case law of the European Courts of Justice on identifiability, confirming a relative concept of anonymization. And based on this proposal, information would be personal data only if a person or entity is reasonably likely to identify the data subject, so the person to which the personal data refers, using realistically available means. And this way, we would be moving away from a really broad and absolute interpretation of personal data that has been adopted by data protection authorities over the years, according to which any information is a personal data if there's anybody with any technical means in the world that is able to trace back to that specific individual. And these expansive views have led over the years to inconsistent enforcement, not proportionate compliance burdens, and uncertainty for innovative services such as research in the healthcare and regulated industries or artificial intelligence and so on. So this is a very much welcome proposal modification, because it would mean that an entity for which the information does not amount to personal data would not be subject to the GDPR, with all the relevant consequences that this entails when it comes to compliance measures to adopt when handling that information. And obviously, this is a key provision in the Digital Omnibus, which, however, has already been strongly criticized by both the European Data Protection Board, so the data protection authorities altogether, as well as some member states such as France or Italy, insofar it would allegedly introduce excessive uncertainty and too much flexibility. I personally do not agree with this criticism, because I believe we are at a point where this approach, this flexible approach to the concept of personal data is needed. And by introducing specific safeguards and industry standards, such uncertainty would not materialize. But we'll see what's going to happen. Another relevant area where the draft regulation proposes specific changes is data processing for artificial intelligence training and use purposes. So among others, it is expressly recognized that legitimate interest can be the legal basis for AI development and deployment, subject to enhanced transparency and an unconditional right of opt-out. So this goes hand in hand also with a proposed modification in the AI Act, where it has been introduced a new exemption for processing special category data for bias detection purposes, as well as more in general for training and development of AI systems. So that would not be limited to high-risk AI systems only. And this is another modification to be welcome, because although the opinion of the European Data Protection Board on AI model training had already confirmed that legitimate interest could be the legal basis for AI training, the guidance still left a lot of let's say, a wide scope for interpretation by individual data protection authorities. And this created the risk of an inconsistent application across member states of the relevant rules. And in addition, these amendments really allow for harmonization with the new requirements introduced by the AI Act. As we were discussing at the beginning, one of the major problems we're seeing is the not always coordinated and harmonized overlap and interplay in between different pieces of legislation. So alignment between the different legal frameworks is essential to ensure legal certainty and consistent enforcement through Europe. In addition to this, there are few provisions that are aimed at simplifying compliance as a whole, really learning from the lesson learned, starting from certain exemptions to the transparency obligations. So, for instance, where the data is collected from a data subject, a privacy notice may not be required if there are reasonable grounds to believe that the individual already knows the key informations about the processing, such as the controller's identity, the purposes of the processing, and so on. But this exemption would not apply in specific cases where particularly intrusive processing is carried out. For instance, high-risk processing, automated individual decision making, or data sharing with third parties or international data transfers. And following a similar rationale, there are simplifications to data subject access rights. And this, I think, is really interesting because is expressly provided for that where individuals abuse data subject access requests for purposes other than protecting their data, or if they do a lot of repetitive requests, data controllers would be able to either reject the data subject access request or charge a reasonable fee for handling it. And this is probably going to be very helpful in the context of data subjects access right requests, used as a form of discovery, for instance, in employment proceedings. This is a typical case of an employee leaving a company, and then there's a proceeding, a suit, and the employee leverages on their access rights under the GDPR to collect information that they may use in a subsequent court proceedings. So in a way, this is an abuse of law. And consistent with the current rules and safeguards for data subjects, the controller will bear the burden of demonstrating that the request was unfounded or excessive. There are similar simplification rules with regards to data breach notifications. So in particular, only breaches entailing a high risk shall be notified, whereas now any breach shall be notified unless it is likely that there will be no risks for data subjects. And also the competent authority, there's going to be a single point of access maintained by ENISA to notify all breaches under not only data protection legislation, but also cybersecurity law. And there's also a change in the time frame for carrying out the notification from 72 hours from being aware of the breach to 96 hours. And finally, it's really interesting because the draft tackles the challenges arising from consent fatigue and cookie banner proliferation, which is another topic where the European Commission held extensive analysis. And when it comes to cookies, there are two additional purposes gaining specific exemptions from consent requirements. So the creation of aggregated audience measurement for the controller's own use, and then maintaining securities. And these are two use cases that had been associated with technical cookies, hence exempted from consent since long time by various data protection authorities guidance. So even in this regard, the proposal just confirms something that was industry practice. And on a practical level, it's very interesting because controllers face new operational requirements. So they must provide refusal mechanisms that are based on a single click and should not ask for repeated consent requests for the same purpose within 6 months of refusal. And this also follows some of the guidelines that had been issued in the past by data protection authorities. And in addition, data subjects should be in the position to give or refuse consent through machine readable signals. And the European Commission is requested to task European standardization organizations with developing necessary protocols. So I think it's really interesting because the success of these proposed amendments, provided that they make it to the final text of the regulation, will also depend on the secondary regulation based on harmonized standards and conformity assessments. I'll leave it now to Jasper, perhaps again.
Thanks, Giulia. So yeah, we will just briefly in our last part, we just briefly look on some further relevant changes as suggested by the Commission in the Digital Omnibus packages. And the most important maybe is that it is planned a full repeal of the platform to business regulation. So the platform to business regulation was is some platform regulation law, which is now largely so largely irrelevant because we now have the Digital Markets Act and the Digital Services Act. So both of them are big platform regulations law. With them, it is the B2B isn't really well recognized and really well relevant anymore. So the Commission, in my view, suggests the right thing to get rid of the platform to business regulation. And the Commission proposes a full repeal, but a fast sunset for selected provisions like definitions and some internal complaint handling. But the idea is basically to eliminate regulatory overlap by the platform to business regulation, and by that again reducing compliance cost, and because mainly it is enough if you comply with the DMA and especially DSA, and there's no need for the platform to business regulation anymore. And that is more an outlook than another change. The bus will not stop with the omnibus. There will be another, or at least envisioned, there's another phase of simplification due to the digital fitness check, and the Commission just started, or the call for evidence just ended in mid of March, and it is seen as a second legislative step for more simplification to the European rulebook. But that is more an outlook. So what are our main takeaways from the ongoing legislative process to the Digital Omnibus? What we would say it goes in the right direction. So it makes sense to the adjustments suggested are pragmatic and make sense. We would hope for even deeper harmonization between the interplay of all these digital laws, so that especially, for example, the GDPR and the Data Act or AI, but also with cybersecurity laws and the DSA. What we particularly welcome is that there's a paradigm shift to see in the Omnibus package. There are at least data protection reforms are discussed, and there is at least considered a modernization of the GDPR, which, in my opinion, and I think Giulia would share this opinion, definitely makes sense, especially in the age of AI. And again, that is to emphasize the outcome is still open. The legislative process is ongoing. We now start trilogue negotiations between Commission, Council, and Parliament. And we don't have a final result yet. And as you know, the trilogue discussion could always again change the direction of travel. With that, I move over to Giulia again for the Q&As.
Thank you, Jasper. So I'm gonna start with one on the GDPR, and then we can alternate. We have 10 minutes, so we have time to go through many questions, hopefully. So would you say it is very likely this amended definition of personal data will make it into the GDPR? And in any event, this amendment follows new European case law. So in practice, we can defensively follow this relative concept of anonymization. How do we align this? So, in all honesty, I am afraid it's not likely this amended definition of personal data will make it into the GDPR, although I would very much hope uh, this would be the case. Why am I saying this? Because we have seen some initial reactions and comments on these proposed amendments. In particular, there's the joint opinion of the European Data Protection Board and the European Data Protection Supervisor, um, as well as some initial opinions and comments by member states, and they all go against these proposed modifications, stating that the proposed new text would create confusion and it would sensibly and unjustifiably narrow down the scope of application of the GDPR, substantially lowering the protection of personal data and the guarantees accorded to data subjects. But in my view, as you correctly said, this is something that is already happening, meaning that we do have the case law of the European Court of Justice. And as we know, the European Court of Justice is vested with interpreting European Union legislation. And also, if you look at the GDPR and the recitals of the GDPR, there's always been these criteria based on the reasonable means available to a controller to trace back to the data subject. So I believe what was twisted it's not this, new proposal about amending the definition of personal data. This is not, really inventing the wheel. I believe that what took a wrong turn at some point was the position and the interpretation given by data protection authorities over the year to personal data, starting from that guidance issued by the Working Party 29 on the concept of anonymization that was unjustly very narrow. So I'm not sure this modification is going to make it through the final text. I know that many businesses and association have been working and are working through their policy team to support this change. I know there's also a lot of tensions going against this, but I think in practice, an approach that follows this concept, so a flexible approach, is defensible under the actual wording, under the actual black letter of the GDPR, and can be defended in court regardless of what data protection authorities said. There's one question. I mean, there's many questions on the A Act, so I'm gonna pick one that is when can we expect a definitive decision on which application dates apply for the application of high-risk AI and watermarking obligations? Frida, perhaps you want to address this?
Yes, of course. That's a very good question. So, as of now, we have the positions by Parliament, Council, and by the Commission, and they are now, as we've said, meeting in trilogues to discuss and agree on a final text. When this will be is not yet certain. There are some reports that say it might be as early as the end of this month. To be honest, it would also be necessary to have a timely decision on this because, as we saw, August 2026, which is not that far away, is the current application date for those obligations. And we wouldn't want, because that is meant to be pushed back, and we wouldn't want that to take any longer than absolutely necessary.
Okay, thank you. Then we can pick on Data Act. So given that the Data Act has only been applicable since September 2025 and enforcement mechanisms remain largely undeveloped, how should one approach compliance investment now? Should we wait for greater regulatory clarity or proceed with full implementation despite the uncertainty? Jasper, you may want to address this.
Yeah, thanks, Giulia. Great question and makes total sense. I mean, me being a lawyer, and in general, we would advise against just a wait and see approach because, I mean, these low enforcement windows just temporary. I mean, it's normal. A new law comes into force, and all member state authorities need to be established. They need to employ new people, staff them. But what we will definitely expect, and you can see that actually with other new digital rules like the DSA, that it will also, with the data access right, you have a lot of contractual touch points. So that will trigger civil litigation, maybe even enforcement, private enforcement by consumer association, or just by, yeah, other businesses. So, and what we also could take away, at least from the Digital Omnibus so far, that the European Commission is trying to position the Data Act as a central pillar of EU law. So the Data Act is gaining importance, not losing that. So we definitely share this view that right now there's some uncertainty, but we would recommend a fast risk-based approach. So start with the most visible compliance issues, transparency, disclosures, access mechanism, and then move on from that to the lower visible compliance topics.
Okay, thank you. I'm going to pick another one on data. So on cookies, you mentioned aggregated measurement for controllers on use. Do you mean first-party analytics will not require consent under the proposal, but be considered necessary to the service under the privacy directive? Yes, I mean, that would, the proposal just kind of slightly broadens the cases where the access to information stored in a user's equipment or reading information already. So storing information, or accessing information already stored in a user's terminal would not request consent. So in addition to the existing exemptions that, as you correctly say, include the provision of a service as required by the user, or operations that are technically necessary to carry out that service, there would be also first-party analytics, so aggregated measurement for the controllers on use. Obviously, these should be carried out by the first party only, without interconnection and without sharing the information outside the controller's domain. So that would be another case where consent is not needed. But as I said, for instance, according to the Italian Data Protection Authority's guidance, this was already a case where the authority recognized that controllers could consider, analytics as similar to, technical cookies, so consent was not necessary. And do you think this section of the e-privacy directive will make it into the GDPR, as this requirement also relates to non-personal data? Yes, obviously, according to the Omnibus directive, there's also going to be, some kind of, so the provisions are going to be intertwined more clearly based on the proposal, also to grant more consistency in between the e-privacy legislation and GDPR. So some provisions of the e-privacy legislation would be repealed, and others, in the GDPR would be added. There's also an interesting addition because there's clear reference that for subsequent processing with regards to cookie, data controllers could rely on any legal basis under the GDPR. So there's also the closure of this loophole, whereas there's specific reference to Article 6 GDPR for further processing. So besides the parts related to cookies that as we know is specific provisions of special law, then there's this kind of consistency, so that this was something that companies already did, but having that written down would certainly give more clarity and would allow for personal data obtained, including under these exemptions, to be processed using the full range of GDPR lawful basis. So probably we can take one last question. We had many, so we can also answer questions via email after the webinar, only obviously if you include your name, because otherwise that would be a bit complex. Perhaps we can take a last question on the AI Act. There's many. So these perhaps, yeah. So I saw on the overview slide of the amendments to the AI Act that there is also a planned change of the AI literacy obligation. Could you briefly explain what would change here?
Yeah, sure. So that is also a very interesting change. So as you may know, under the original AI Act, there is a rather broad requirement that all providers must ensure that users of AI and providers that their staff have appropriate AI literacy training. And this was seen as very well intentioned, but perhaps a bit too far reaching and also hard to enforce. So the Commission suggested to remove this blanket obligation on companies and instead shift the responsibilities onto public authorities so that they can provide literacy through workshops and seminars, etc. However, it is actually a bit unclear how far-reaching the shift will be in the end, because now that Parliament has chimed in, they still want providers to support staff literacy. So we will have to wait and see for the final version here.
Okay, perhaps we can take one last data act. We have 2 minutes, Jasper, so super quick. Perhaps this one is going to be short. This is something I think you already partly addressed. So the presentation notes persistent tension between the Data Act's access to data approach and the GDPR's privacy by design requirements. How should companies navigate potential conflicts?
Yeah, that's an issue which was many stakeholders actually flagged in the omnibus proposals. And as you know, in general, the GDPR prevails over the Data Act. So if there's a genuine conflict, GDPR obligations take precedence. But it is. At the end, it's difficult if there's a genuine conflict. And to be sure, what you would want to do is maybe document your legal reasoning why you didn't grant access based on GDPR concerns when you are balancing both obligations. So once an authority approaches you, you have documented your considerations and can easily defend your position.
Okay. So I think we are at time. We will follow up in writing on the questions where, I mean, there's a lot of questions, so really thank you for that. But we are not able to address all of these. For those that have been made not in an anonymous way, we'll follow up in writing. And we hope you had an amazing time with us, because we did have. And there's going to be a follow-up webinar in the same series in May. So stay tuned for the invitation. And we're going to continue exploring the digital regulations jungle, as we like to call it. Have a nice rest of your days, and thanks for attending.